Part 2 is the McCarthy era. To begin in an objective, reserved, academic, and professional tone, Joe McCarthy was a petty little demagogue, ruthless and despicable from the word go, who really doesn't deserve to be remembered, celebrated, or honored at all, but he gave his name to the era which frightened Americans and nearly destroyed free speech. And I really do believe that is an objective, reserved evaluation. There are lots of reasons for this, and some of them have to do with McCarthy and some of them others, including Richard Nixon. Alger Hiss was exposed as a communist spy. He denied it. He was convicted of perjury. His prominence made Americans more fearful that there were, in fact, lots of communists in the federal government. America emerged from World War II confident, thinking it would be a Pax Americana. You'd have both peace and American domination. And then you had the spectacles of Stalin conquering Eastern Europe, the fall of China, the retreat of Chiang Kai-shek to Formosa, the Soviet detonation of the atomic bomb, along with the revelations that Americans, the Rosenbergs, had helped Stalin get that atomic bomb. In the midst of all of this, Joe McCarthy stood up in West Virginia and claimed that there were 205 communists in the State Department. He then delivered subsequent speeches affirming his accusations, but changing the number in an almost comical fashion. Congress responded to McCarthy by passing laws. One was the McCarran-Nixon Internal Security Act, which required registration of communists. A courageous Harry Truman vetoed it, but he was overridden by a panicked Congress. Perhaps much of the spectacle is symbolized by Richard Nixon's attacks and Joe McCarthy's attacks on Adlai Stevenson, Dean Acheson, and most of all, George Marshall, who'd been the architect of victory in World War II, author of the Marshall Plan, and even his protege, presidential candidate Dwight Eisenhower, refused to come to his defense in one of the moments that I think President Eisenhower was, well, not exactly proud of. It was not his finest hour. In popular culture, we remember the era mostly for the Hollywood blacklist. Now, there are lots of stories and plays and movies that spring out of the experience, but the one I like to tell to my students is a story of Olivia de Havilland. I'm always worried every year that the name Olivia de Havilland will fall out of memory, but her presence in Gone with the Wind apparently is going to keep her even in the memory of some of my youngest law students and most recent law students. Olivia de Havilland tried to lead the charge against communists in Hollywood. She once held a party, a caucus of anti-communists to show that Hollywood was against communism. And when a friend of hers, a young actor with whom she'd worked several times, came to the party, she stopped him. She thought he was a leader of the Stalinist cadre. "Why are you here?" she asked. And she had reasons. He'd been on the director of the United World Federalists, a dangerous organization. He had denounced the Un-American Activities Committee of the House. He'd campaigned for the firebrand Hubert Humphrey in Minnesota, and he was a very emotional New Dealer. But Ronald Reagan denied he was a communist. Yes, Ronald Reagan was accused of being a communist during this period. And matter of fact, for those of you who like to trace romance through American history, Ronald Reagan met Nancy Reagan when Ronald Reagan was trying to protect Nancy Reagan from being on the Hollywood blacklist. These were events that the Reagans did not discuss in subsequent years. Well, it was a terrible time. Virtually anybody could be accused and have their career threatened or destroyed, whether it be in acting in Hollywood or being a commentator on the news or a professor at a university. Well, what's going on in the Supreme Court? Well, the Supreme Court rendered a decision in 1951 called Dennis versus the United States, and it was not the Supreme Court's finest hour. The case arose from the Smith Act of 1940, signed by President Roosevelt. It was a parallel statute to all of those state statutes, including the ones in Gitlow and in Whitney versus California, which said it was unlawful to advocate overthrow of the United States government. A few obscure individuals in Denver were prosecuted and convicted, not of advocating overthrow, not of attempting overthrow, but of conspiring to attempt to advocate overthrow. They were convicted and their case goes to the Supreme Court. And in the course of the proceedings, the federal courts conclude the Communist Party in America was a highly disciplined organization committed to covert subversion of the existing order by force and violence. And on the basis of this finding, this factual finding that there was something special, organized, and effective about the Communist Party, the statute was upheld against constitutional attack, and the convictions were sustained. But the Supreme Court began to wring its hands. There's no majority opinion of the court. There is a plurality opinion written by the Chief Justice of the United States, a man whose name I'm sure everyone remembers, Fred Vinson. That's the answer to a trivia question for you all. Who was the last person appointed by a Democratic president to be Chief Justice of the United States? And the answer is Fred Vinson, 1946. Before I'm born, I'm thoroughly confident that I will never see again a Chief Justice appointed by a Democratic president. But in any case, Fred Vinson was the man who was the last Democratic appointed Chief Justice, and he wrote the opinion for his friend Harry Truman, incumbent President of the United States, and upheld the law. Mr. Vinson's opinion was an essay of old doctrines. It's reasonable to fear the communists, he said. The government has a legitimate interest in preventing communism. The clear and present danger test, which had seeped into precedent back in the Holmes and Brandeis era and had actually resulted in a few convictions being overturned at the local level, was too protective of free speech for the communist menace. Therefore, the clear and present danger test did not apply. He began to argue that you cannot wait. You've got to deal with the threat in the early stages. The words cannot mean the government may act. It must wait until the putsch is about to be executed, the plans have been laid, and the signal is awaited. Well, that word, putsch, spelled P-U-T-S-C-H, is a German word, and is a direct allusion to the experience of the Third Reich. In 1951, we'd just gone through World War II, and the disaster that can come from waiting too long was all too apparent. Vinson pointed to that history and wrote, certainly an attempt to overthrow the government by force, even though doomed from the outset because of inadequate numbers or the power of revolutionists, is sufficient evil for Congress to prevent. And so the court announced a new test. It's no longer the it's no longer the bad tendency test of the Sedition Act of 1798 era. It is no longer the clear and present danger test of the Holmes and Brandeis dissenting opinions. Instead, it's a diluted clear and present danger test, which amounts to a kind of case-by-case balancing. If the danger is big enough, no matter how improbable, the government can act. This began a long debate that isn't resolved for almost another 20 years between those who believe that free speech is to be governed by ad hoc case-by-case balancing of gain and pain, cost and benefit, evil versus good, and those who believe you have to answer Alexander Hamilton's question about defining a principle of free speech with a qualitative formula. Hard, conventional, difficult to evade. Those are learned hands words, you may recall, from an earlier generation. Felix Frankfurter is a very influential member of the court, former professor of Harvard, proud of it, tended to think his colleagues weren't quite up to his intellectual mastery. And Felix Frankfurter becomes the great dedicated defender of ad hoc balancing. His opinion, his concurring opinion, in Dennis versus the United States becomes something of a landmark and a typical expression of the idea. Here are his words. Absolute rules lead to absolute exceptions, and such exceptions eventually corrode the rules. The demands of free speech in a democratic society are better served by a candid and informed weighing of competing interests within the confines of the judicial process than by announcing dogmas too inflexible for the non-Euclidean problems to be solved. Felix wrote well. Felix was clear-minded. And Felix spoke for all of those who believed that the law cannot be simplified into a few qualitative rules. More controversially added, free speech cases are not an exception to the principle that we are not legislators and that direct policy making is not our province. Now, at this point in time, the Supreme Court is torn apart by personal vendettas. Felix doesn't like Hugo, and Hugo doesn't like Bob, and all of them don't like Fred. And they're all described, famously, as 9 scorpions in a bottle. So they all write their own opinions, and Black and Douglas begin to write their view that free speech must be an absolute, that there should be no balancing, that no law means no law. Now, sympathetic though I am with their sentiment, the problem is that there is no doctrine or legal methodology surrounding this no law means no law idea for courts to deploy in case after case. No law means no law is a soundbite, good for talk shows a generation later, but hardly of any use to a lawyer in a real case. So for a long time, those who believed in a candid and informed and sensitive and sophisticated and intellectual balancing carry the day. Meanwhile, criticism of the clear and present danger test is growing. Now here, I need you to think in practical terms. If we apply the clear and present danger test to the communist menace case, consider what a trial would look like. What would prosecutors have to show in order to show that the Communist Party poses a menace? It's probably difficult for those of you who are not used to thinking like a lawyer in terms of witnesses and testimony to imagine. But you'd have to call sociologists and economists and political scientists and commentators and public opinion pollsters, all designed to say the communists do or do not pose a threat, when in fact, probably the best expert is somebody who's got their experience putting finger to the wind and running for office. They have a sense of which way the winds blow. Courts aren't very well equipped to take that data and turn it into a principle. And that's what the Supreme Court was worried about. Clear and present danger depended on findings of facts the court was not well equipped to make. And that's something Thomas Emerson expressed in the aftermath of this era. If the Supreme Court had taken the factual issue seriously in the Dennis case and attempted to assess whether the utterances of the Communist Party actually constituted a clear and present danger, it would have plunged into a consideration of a mass of historical, political, economic, psychological, and social facts. This judgment would have included both evaluation and prophecy no court is competent to give. Well, that left us without much in the way of principle and protection. Dennis versus the United States is on my list of the worst cases ever, along with Dred Scott and Plessy versus Ferguson, because it essentially says we don't know how to protect freedom of speech, and so we're not going to. As for the McCarthy era began to die almost immediately after Dennis versus the United States sinks into the doctrine. You know the stories. Edward R. Murrow. Joe McCarthy is censured by the Senate. Joe McCarthy dies in 1957. And that same year, 1957, we get something known as, I kid you not, Red Monday. Red Monday is a day when the Supreme Court announced a series of decisions on free speech involving the McCarthy era. And you may not know this. Earl Warren was targeted for impeachment, not because of Brown versus Board of Education, but because of Red Monday. All those billboards all across the country, impeach Earl Warren, pop up not over the racial issues, but over the Red Scare issues. Time magazine took note of it in a June cover story article on Earl Warren. That day, the Supreme Court announced a series of decisions, and Time magazine compared the day to Black Monday of 1935, when the Supreme Court struck down the New Deal in a series of shocking, reverberating decisions that made Franklin D. Roosevelt very unhappy. Meanwhile, Red Monday precipitates a debate. According to Time magazine, one Chicago lawyer said, "This court is unanalytical, it's vicious, it's stupid, it's alliterative, it's subjective." California judge responds, "The decisions are sound and timely. The trials of communists here are comparable only to the trial of dissenters in Hungary. Neither should have taken place." So it precipitates a debate, not a resolution. As for the assessment of Earl Warren, Time magazine issues a couple of very interesting pronouncements. By comparison, Earl Warren's court has moved with drastic speed toward the implied concept not of clear and present danger, but of very little danger at all. If one effect of the Warren Court's drastic change was to broaden areas of civil liberties and the best traditions of constitutional law, another very practical and measurable effect was to slow the prosecution of communists. In the drastic change of direction, state laws against subversion, state municipal procedures for judging the worthiness of teachers, and the key federal statutes aimed at communists have been eliminated or weakened. Good or bad, this is a consequence of great moment. Naturally, our generation has forgotten it. Perhaps it did indeed accurately reflect the lessening of the communist danger, but the nature, spread, and fabric of the decisions indicated something more serious. The present court majority never thought communism much of a danger at any time. And that's probably the truth. Now, if you go back and you look at the decisions, which I'm about to mention briefly, they don't get discussed in today's constitutional law textbooks. As shocking as they were to the population of June 17th, 1957, Red Monday, today they're taken for granted. There's Watkins versus the United States. This overturned a contempt citation of a communist union organizer who refused to identify other communists before the House Un-American Activities Committee. The fact he's released from jail and his contempt citation is thrown out is big news in 1957. Today, something like that couldn't happen, and hardly anyone notices it. For us, teaching at a university, we should fall in love with a case that has been forgotten, Sweezy versus New Hampshire. This overturned the contempt citation of a university professor who refused to disclose the contents of a lecture he had delivered at a state university. And he refused to discuss his knowledge of the Progressive Party of the New Hampshire state. Well, again, this is one of the few cases that makes reference to something called academic freedom. Truth is, there aren't that many decisions like that, but by and large, it's been forgotten. Perhaps most significantly for the time, you had the case of Service versus Dulles. Now, this overturned the dismissal of an old China hand, one of those employees of the State Department, a Foreign Service officer, who had dared to criticize Chiang Kai-shek. And these were the poor folks who felt the real brunt of McCarthyism in the middle of the 1950s, when this man is restored to employment, despite the wishes of John Foster Dulles, Secretary of State. It's big news. Now, the persecution of those old China hands retarded Chinese foreign policy, American foreign policy regarding China for a generation, but at least that formally ended in 1957. Now, most of these cases were eventful and important, but they didn't change the doctrine very much. At this point in time, 1957, we still don't have much in the way of qualitative, coherent doctrine to deploy. We have the beginnings of it in another case decided that day, Yates versus the United States. This case concerned the same statute as Dennis, the Smith Act of 1940. It did not overturn the decision wholesale. It respected the Dennis precedent. But what it said is we're going to interpret the statute carefully and narrowly rather than broadly. We're going to insist that before a person can be convicted of violating the Smith Act, they must have used words that literally amount to incitement of actual, imminent, violent conduct. Not just general advocacy, not just a general argument, but more in the nature of somebody standing on a courthouse steps and inciting a lynch mob to lynch a defendant. And that focuses the attention in the next generation. We see that insight, which is developed by John Marshall Harlan, an unsung hero of freedom of speech, into a way of resolving the clear and present danger test, its ambiguities, and its criticisms into a modern test of free speech that still endures today. And that'll be the talk I'll give in a few moments. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.